Federal judge in Los Angeles will soon decide on whether the Trump administration violated federal law when it deployed National Guard soldiers and Marines to Los Angeles following June protests over immigration raids. 3 days of arguments concluded today between the state of California and the Trump administration. The issue at hand: did the president violate an 1870s law that forbids military being involved in domestic law enforcement activities? CBS News legal contributor Jessica Levinson has been following the latest developments, and she joins me now. Jessica, I'm always grateful to have you. Remind my audience what this 1870s law is and how it became the center of this conversation about the legality of this deployment.
Exactly. One, it's so great to be back on the takeout. And two, let's go all the way back to the late 1800s in really the Reconstruction era, right after the Civil War. How did this law, the Posse Comitatus Act, come to be? Well, in part because there were federal troops that were enforcing federal civil rights laws after the Civil War. And Southern Democrats essentially wanted them out. Troops eventually left. And about a year later, we get this federal statute that says when it comes to the military, initially it was just the Army, then it expanded out to essentially all parts of the military. When it comes to the military, don't directly enforce domestic law. That is for domestic law enforcement agencies, both on the federal and the state level. Now, I know your next question is going to be, what's the difference between directly enforcing, which is prohibited, and supporting, which is something that's allowed? And certainly we can get into that, but why is this the subject of the case now pending in San Francisco before Judge Breyer? Well, that's because California is alleging that once the National Guard and the Marines were on the ground in Los Angeles, that they cross the line from acting in a supporting role, which is again okay, to acting to directly enforce domestic law, which is not.
And the application of federal immigration law does fall under the federal government. So there is some latitude there. And what other arguments came up in terms of what the judge heard? And as I read through some of the transcripts, there were some questions even within those who were trying to carry out the administration's will about whether they were being loyal enough and whether or not they had the legal authority and all these kind of intricacies that they were trying to work through. And when there was a disagreement, the loyalty card was put on the table.
Absolutely. Some dissent in the ranks. If I could pick up on the beginning of your question where you said, we're talking about federal immigration law, this falls within the federal government. That's exactly right. But when it comes to the president's decision to say, I'm federalizing the National Guard, I'm deploying the Marines, they cannot, under the Posse Comitatus Act, as you know, act like ICE agents or act like DEA agents. They can act in a supporting role. They can provide equipment. They can provide information. They can provide transportation, but they can't be the ones, unless there's an exception, actually arresting people, seizing people and property, detaining people. And that's really what this case, and to your question, the questions about loyalty, that's what this case is about. And that's part of what the judge heard, Judge Breyer, about whether or not the National Guard and the Marines, were you acting in a supporting role? What were you told to do? What did you agree to do? Or did you kind of cross that line into actually being the ones to enforce federal law, which, again, you can't do unless there's an exception to the Posse Comitatus Act?
An important case, and we will keep a very close eye on it, and we rely on Jessica Levinson all the way to take us through that. Jessica, always a pleasure. Thanks so much.